So late Friday, the Fifth Circuit Court of Appeals issued a horrific opinion that says the following. If you are undocumented, whether you came across the border, whether you came and overstayed your visa, and maybe you are applying for asylum or you had temporary protected status and you no longer have it. If you are undocumented, quote unquote, then you will now be held in detention without a bond. That decision, 2-1, came out of the Fifth Circuit. And of course, they dropped it on a Friday. And of course, it has so many nuances that are important for you to understand, because that ruling is going to have huge impacts in the way that the Trump administration continues to move forward with its draconian efforts to kidnap people off the streets. My friend, colleague, and the brilliant law professor Steve Vladeck joins me now. It's a little bit of a longer episode, but I urge you to stay till the very end because he connects the dots. He explains why the surge that we saw toward the end of the summer last year is tied to this specific immigration federal statute, and why the Trump administration has figured out that it thinks that it has the winning answer to be able to hold people without bond for an indeterminate amount of time. Take a listen. And joining me now is the man, the myth, the legend, Steve Vladeck, who makes it all accessible, even for people like me, to be able to understand. Steve, I have to try to find some joy in my life, and it's hard these days. And then I get hit with this late Friday opinion out of the Fifth Circuit, which I had to have you on to talk about today because its potential impact is so horrific and far-reaching that I really need people to make sure that this is on their radar. So let's talk about the Fifth Circuit and what it decided on Friday. The top line takeaway is, regardless if you entered the country through a port of entry at the border or some other way, you are now deemed to be, quote, illegal, according to a 2-1 decision out of the Fifth Circuit Court of Appeals. And as such, the Trump administration can detain you without bond while you are going through the process of the immigration enforcement programs. Is that right?
That's right. And it's actually, I mean, Katie, it's at the heart of so much of what the administration is doing because, before last year, you'd have lots of folks who might have been subject to arrest because they were removable from the country, but the government wouldn't arrest them because they wouldn't be allowed to detain them without showing that they were a flight risk or a threat to themselves or others. Now the government doesn't have that burden. Now they can arrest every single person who, in the government's view, is removable for any reason and detain them indefinitely while their removal proceedings unfold. It is a stunning interpretation. Katie, there's a reason why of the 3,000 cases under this issue that have come up in the federal district courts in the last 7 months, 93% of them have been resolved against the Trump administration. And yet here's the Fifth Circuit saying, we're good.
I want to get into those numbers. You and I are both fans of Kyle Cheney over at Politico. He wrote a piece about this Fifth Circuit decision late Friday. He reports the following. At least 360 judges have rejected this expansive interpretation of the federal law, and that's in more than 3,000 cases. So I want to let everybody understand here. In more than 3,000 cases, at least 360 judges, and that includes Trump-appointed judges, let me be clear, right? It's not just, quote, left-leaning activist judges. While just 27 judges have supported what the Fifth Circuit decided on Friday in only about 130 cases. Steve, in your newsletter, One First, you noted that this ruling from the Fifth came down just 2 days after oral arguments. Before you and I hit record for this interview, I said, Steve, that suggests to me that these judges may have predisposed or pre-decided what they were going to do with this before they even heard the oral arguments.
I think that's right. And Katie, I mean, it's worth backing up a second and just putting this all in the context. I mean, when folks see headlines, for example, out of Minneapolis, where Chief Judge Schiltz was complaining about ICE defying all of these release orders in immigration detention cases, that's these cases, right? So much of the on the ground surge that the government is attempting is based on this fakakta theory of immigration law. One that, I mean, it's not just the numbers, Katie. The best possible reading of the government's argument would basically mean that for 30 years, which is how long these statutes have been on the books, the statute meant the opposite of what everybody thought, and no one noticed. Right, that the Trump administration didn't notice during its first term, that the Bush administration didn't notice, that no one ever thought, oh, maybe the Congress meant this, except until some guy at ICE figured this out last summer. It's not just, Katie, the one-sided nature of the lower court rulings before Friday. It's that one-sidedness reflects the fact that this is not that hard of an argument, that you have to twist the law basically into a pretzel to get to the conclusion that the Fifth Circuit drew, and you have to be stunningly indifferent to the very real human consequences, which is, Katie, someone who's been in the country for 60 years, who's never committed a crime, right, who, has multiple generations of offspring who are citizens living in this country. All of a sudden, if they've never applied to adjust their immigration status, they can be treated as if they were stopped at the border. I mean, that is not just not what the statute requires. It is insane as a matter of ordinary common sense.
Yeah, and I want to dive into the opinion for just a second to give some people some important context, because the opinion does go back into the statutory background of this law. Because before 1996, Immigration and Nationality Act said that there was a distinguishing issue between who gets detained and who doesn't. And that distinguishing factual factor were people who presented at a port of entry and those who, quote, evaded inspection. Meaning, if I went in through the border or at a port of entry, my detention evaluation would be different than if I evaded, maybe coming in that way, evaded inspection by Customs and Border Patrol or Customs and Border Protection, and then I was stumbled upon at a later time, or maybe I even applied for asylum, right? I'm going through the legal process. My detention evaluations were different. But then the opinion says that in 1996, the Illegal Immigration Reform and Immigrant Responsibility Act, I mean, Jesus, that's a really long thing. It aimed to change this disparity. And it basically says Congress provided for the inspection by immigration authorities of aliens present in the country together with aliens arriving at the border. So they ended up saying in 1996, it doesn't make a difference how you got into the country. We are now going to look at you a certain way. And then part of that means you do not get to qualify for a bond at this point.
And the bond part, I think, is such an important piece of this, Katie, because the bond part is what makes this so ridiculous.
Yeah.
So before 1996, there were lots of folks who could be subject to immigration detention, but who were entitled to a hearing, who could go before a judge and say, wait a second, like I'm actually, not a flight risk. I pose no danger to anybody. I've never broken the law. And they'd be released, right? And the sort of one of the real, I don't want to use the word innovations because that seems like it's a positive, but one of the real sort of shifts that Congress undertook in 1996 was to widely expand what's called mandatory detention, the categories of individuals whom the executive branch would not have discretion to decline to detain. But Katie, that expansion was not about covering like every single undocumented immigrant in the United States. That expansion was about making it easier for the government and making it harder for presidents who might be soft on immigration to release folks from custody if they were stopped at or near the border. There's nothing in the legislative history leading up to the 1996 statute. There's nothing in 29 years of practice under that statute that suggested that Congress was meaning to and was understood to treat every single person who's out of status as if they had never been in the United States previously and as if they hadn't been here for decades. And that's a huge problem, Katie, because we would think if Congress were going to so radically upset the conventional understanding of the different rights people have if they've been living in the United States versus not been living in the United States, that someone would have said so. As opposed to, no one figured this out until the acting director of ICE last July. I mean, it's strange credulity that this was ever a viable argument if no one had come up with it until last summer.
And to that point, the two petitioners, the two people that are at issue in this case, their cases were consolidated, Steve. One entered the United States in 2009. The other entered the United States in 2001. And it was only last year, 2025, that they ended up being kind of ensnared in what I am calling this wide Trump net of immigration enforcement, in quotes, I have to put that in quotes, and that they were told, you're not going to be released while we're going through this process with you. And then they filed these habeas petitions, which we've covered a lot here with you and separately from you. They filed these habeas petitions, and district court judges evaluated each of their claims and said, you don't have to be held indeterminately while we are going through this process with you for the reasons you said a few minutes ago. You don't pose a risk to yourself or to society. You're not a danger. You're not a violent person. You've been here for so damn long. You have roots in the community. It seems to be a pretty safe bet that you're okay to be released on certain conditions of release. And yet now they've completely erased. The Fifth Circuit has said, we're eliminating judicial discretion in this regard. And we're saying, it doesn't make a difference how you came in. If you're in here and you're, quote, undocumented, we get to hold you with no bond.
And what's really stunning about that, Katie, is we have to add that together to the steps the Trump administration has taken to take millions of people who were in the United States under some kind of lawful or temporary status, for
like
example,
asylum or something, right?
Or those or the TPS programs, the temporary protected status programs, where you could not say someone like a Venezuelan who was here under TPS or a Haitian who was here under TPS, you couldn't say they were an undocumented immigrant. You couldn't say, as the right so lets you, that they were illegal. The whole point of temporary protected status is they were protected. And so the day after the administration says, oh, whoops, you're no longer protected, now they can be arrested and held indefinitely. I mean, that's just, it's not just the cruelty of it, Katie. It's that we know enough about the law to know that that is how mistakes happen. That is how, sort of we are engendering violence against these folks. And, whatever people want to say about the so-called worst of the worst, the violent criminal immigrants who apparently, the Trump administration claims is going after, that's not who this policy is about. This policy, those folks were already arrestable and detainable under the authorities that already existed. Those bond hearings would have been losers, right? The folks we're talking about, the people who are affected by this policy shift and by the Fifth Circuit's ridiculous decision suggesting that somehow legal, Katie, these are the folks who would have gotten bond. These are the folks who don't have a criminal history. These are the folks who may not have even broken the law, Katie, by being out of status. It is not necessarily a crime to be undocumented in the United States. And these are folks who, presumably would win their bond hearings. And so what's really stunning about this is that this whole policy actually puts the lie to the claim that this is about violent criminal non-citizens. Because the whole reason why you don't want bond hearings is for the folks who are not violent criminals. And those are the folks
able
who are
to show that it's a lie. Exactly. That it's all a lie. It's not just going after, quote, violent criminals. It's just going after people indiscriminately who fit a profile. It's basically racial profiling at this point.
Well, and I think it's worth tying a couple threads together. I mean, it's really striking to I don't think it's a coincidence, for example, that the memo articulating this interpretation, which was written by the then acting director of ICE last July, that it was followed in close succession by the ICE surges that we saw in Chicago and Los Angeles and other cities, because those surges wouldn't make sense if all the people who were getting arrested would then have been released. Right? Like there would have been no reason for the surge unless you were going to be able to hold these people for some period of time. It's this policy that is the sort of legal fig leaf for why the surge makes any sense at all. And that's just like, it just drives home how this has nothing to do with anything other than arresting people who are out of status and nothing beyond that.
Steve, you said something a few minutes ago I wanted to go back to because it really struck a chord in me. Trump, this is his second term. He had a bite at the apple in his first term with his and we saw what the hell he did with immigration in the first term. It wasn't like he wasn't creative back then. But they, as in the Trump administration, didn't take this position back in the first term legally. And yet it just occurred to somebody. Again, I don't think it's a failure of imagination, Steve. I just think, we just need to kind of almost begrudgingly appreciate the creativity that's come out of this freaking regime second time around. Somebody figured it out the second time around. Oh, well, you know what? This shit actually may stick. If we can get it in front of a Fifth Circuit like Judge Edith Jones and Judge Kyle Duncan, a Reagan appointee and a Trump appointee, right?
That's right. And I think, let me add one more point that I think will help drive home why this particular policy has been especially chaotic compared to all the others. It's not the number of people we're talking about, Katie. The reason why there are so many court cases, you mentioned the Kyle Cheney piece about 3,000 cases.
Yeah.
That same 1996 law, IRERA, the Illegal Immigration Reform and Immigrant Responsibility Act, has a really nasty jurisdiction stripping provision which bars federal courts from issuing class-wide injunctive relief in any challenge to immigration detention authorities. And so that provision, that statute, that obscure statute that no one outside of the immigration bar even knew existed, is why every single individual person who's been picked up under this policy and who thinks they'd be entitled to bond but for this policy has to bring their own habeas petition. It's why dockets are flooded in Minneapolis and other cities. Like, this is exactly why it's been a mess, not just on the enforcement side, but on the court side. This is why that government lawyer had a meltdown in federal court last week.
Please jail me for 24 hours because I need a break. Who got fired, by the way? DOJ fired her in the end.
But Katie, I think folks weren't tying the threads together. The 88 cases she was assigned were 88 habeas petitions under this policy. And so, there's so many different threads of what is currently going on in our streets and in our courts that can all be traced back to this one odious, lawless policy that now gets this, modest imprimatur because the Trump administration moved very carefully and very deliberately to make sure that it was the Fifth Circuit that was the first federal appeals court to get its hands on this issue.
Before we get into the cherry picking of the Fifth Circuit, I do want to go back and kind of just make sure that our viewers understand what you just said, because I found this to be really important. In other instances, a plaintiff can go to court, a petitioner can go to court and say, I have sustained injuries as a result of conduct that has violated my rights or violated a law, okay? And I also am representative of a group of people that have the same treatment, the same injuries, like the same stuff, which
like the birthright citizenship cases.
What, say that again?
Like the birthright citizenship cases, right?
Exactly.
Where it's a nationwide class action on behalf of all the people who'd be affected by that policy.
And so I could go to court and say, I can be the kind of face of this group of people. But you're saying that under this particular law, this federal law from 1996, it has a specific provision that doesn't allow somebody like me to come forward to a federal court and say, I can be the face of and representative of this whole group of people. So that means each and every person who is potentially or is impacted by this law has to file a habeas action in and of themselves, which of course will drown the system that already had immigration judges pulled and also now has overworked federal district court judges as well.
So, and I think the key is, the number 3,000, folks might be like, how are there 3,000 cases about one policy? Numbers probably actually higher. Right? This is just, right? These are the cases that just Politico and I believe the University of Iowa Immigration Clinic has been tracking. But Katie, there's a broader point here, which is, I think folks who the sort of the meltdown by the government lawyer last week, right, is not just sort of one lawyer having a bad day. It is a system that is being, if not deliberately, at least knowingly pushed past its breaking point, where every single sort of problem that this volume creates redounds to the government's benefit. If it's hard to file a habeas petition, that means the person stays in custody. If ICE is being slow in responding to DOJ requests, that means the person stays in custody. If someone's moved out of the jurisdiction before they can file a habeas petition, they stay in custody. Every single piece of this, whether by design or by coincidence or just by negligence, right, means more people are spending more time in what is probably unlawful immigration detention. Katie, and that's before we even get into the increasingly alarming circumstances and conditions of that detention.
Which are violative of people's rights in and of themselves in terms of cruel and unusual. Steve, talk about this cherry picking. So the Trump administration, you and I know this, we live this daily. They're losing a lot. Putting aside the Fifth Circuit's decision from Friday, before Friday, they were hitting the win-loss column. It was heavily in the loss column. But one thing you've pointed out is the way that this is kind of teed up. The Trump administration has no obligation to per se appeal every loss that it has. It can cherry pick which losses they want to appeal and do so in front of a traditionally very conservative Fifth Circuit Court of Appeals.
100%, and that's what happened here. I mean, so, if you go back and track these 3,000 plus cases chronologically, I mean, the administration started losing this issue, Katie, I think by August of last year.
Yeah, pretty early on.
There were reports of these kinds of opinions coming out. By November, it was a flood. I mean, I wrote my first piece about this for the newsletter. I wrote, I think at the very end of November, early December.
You did, yeah.
And what's striking is, I mean, this was the exact concern that Justice Elena Kagan raised during the birthright citizenship oral arguments last May, which is that if the government just never appeals, it could force, all of this sort of retail litigation. But the government actually did one thing more sneaky than that, right? It picked one court to appeal to. It didn't appeal in New York, where the Second Circuit is actually a pretty ideologically diverse appeals court. Didn't appeal in California or Oregon or Washington, where the Ninth Circuit is also a pretty ideologically diverse appeals court. It waited to lose cases in Texas so that it could appeal to the Fifth Circuit. And Katie, what's even more striking than that is, in her dissenting opinion, Judge Douglas, who was the dissenting judge on this 3-judge panel, points out the various procedural machinations that the panel undertook to move fast once they had the appeal. So the government waited and waited and waited to appeal one
found
of these
the
cases,
right perfect storm of people.
Found the right appeal, right? Found a Fifth Circuit case, and then moved heaven and earth to make sure that the very first opinion from a court of appeals, right, was from the Fifth Circuit. Now, the government would not have known in advance, exactly who the 3 judges on their panel in the Fifth Circuit were, but you throw a dart at a wall-sized dartboard, you're going to hit something.
Well, especially in the Fifth Circuit. Okay, right. Let's be very clear.
Right. The odds. I mean, I haven't run the combinatorics lately, but the odds of the government getting a unfavorable panel, like a radically unfavorable panel in the Fifth Circuit, we're probably in the ballpark of 10 to 15%, and lower there than probably any other federal appeals court, except maybe the Eighth Circuit, which currently has the Minnesota cases.
And look, and I'm going to ask you in a couple of minutes your personal familiarity with Judge Jones, who was one of the 3 judges on this panel. But I did want to follow up with this. So this is a Fifth Circuit decision, a federal appeals court. It is for 2 gentlemen that filed habeas petitions, one in the lower court. They were ordered to be released, and then the government appealed. And were released, excuse me, and the government appealed, and now they're actually facing this adverse ruling from the Fifth that says we're reversing and remanding, meaning we're kicking it back to the district court judges to basically put them into no bond detention. So you have 2 options now. These 2 men, yep. They can either ask the entire en banc, meaning the entire Fifth Circuit bench, to agree. They don't have to, right? Agree to listen to their case. Or they can do on an expedited basis, SCOTUS, hello, SCOTUS, take this, because there's been these inconsistent rulings that have been coming pursuant to this particular federal statute. I mean, Steve, if you were a betting man, if you were counseling these particular petitioners, what would you tell them to do in this instance?
I mean, it's a good question. So, but can I insert one sort of before we get there? So,
oh yeah, please.
The Fifth Circuit's ruling, Katie, has 2 different sets of effects, and I actually think it's important to break out the 2 effects.
Okay.
So for these 2 guys specifically, yes, it means their detention all of a sudden is legal once the mandate issues. That is to say, once the formal paperwork in the Fifth Circuit issues, and that doesn't happen overnight. So they're still, at least at the moment, at liberty.
Exactly.
Right. But the bigger problem, because we're talking about a huge volume of cases, is that from the moment that decision hit Friday night, it is precedent within the Fifth Circuit, which means federal district courts in Mississippi, Louisiana, and Texas, the 3 states in the Fifth Circuit, are now all bound to follow that decision in any immigration detention case raising this issue. And so the reason why I think it's useful to separate those two things is because I actually think which of those buckets you're focused on would lead to a different answer about what you would do next. The reason why you might go for en banc first is because under the Fifth Circuit's rules, if the Court of Appeals agrees to rehear the case en banc, the second they agree to do that, the panel decision's vacated and there's no more precedent. At least until the full
So
court
you could
rules.
knock out that precedent for those 3 states if you successfully get the en banc to agree to hear
Even
it.
if the en banc court takes 6 months to a year to actually hear and decide the case,
It's
the
knocked out.
panel decision's wiped out in the interim.
Okay.
And so, if you're thinking about this more not just about these two guys, but about like what's best
Everyone
for
else
the
is implicated. Yeah.
thousands and thousands and thousands of people, and Katie, the others who the government may soon try to move into Texas and Louisiana, right? To take advantage.
People need to understand this, Steve. Yeah. For habeas, you actually have to be physically, geographically present in the jurisdiction within which you're seeking your habeas relief. If the government, as we've seen, for the filing, at the time of filing, and if the government does what we've seen them do, which is arrest you in Minneapolis and then send you to Dilley in Texas. And if you haven't filed in Minneapolis before you get to Dilley, you're SOL. You're shit out of luck. This is what they've been doing.
So this is why en banc is one is perhaps what we're going to see first. Now, the caveat there, Katie, is it's the Fifth Circuit, and it's 17 active judges in total. You would need a majority, so you would need 9 of the 17 active judges to vote for en banc rehearing. It would basically come down, Katie, to the 4 somewhat less crazy George W. Bush appointees on the Fifth Circuit. And, they've been not completely in the tank for the furthest right-wing, reactionary immigration.
Well, they had
stuff.
that Alien Enemies Act decision that they were
the Alien Enemies one.
Right?
They also, it was a couple of those sort of Bush appointees who also put the sort of kibosh on SB4, Texas's effort to create a state-level deportation system a couple of years ago. Gotcha. So I don't mean to say like it's clear. I think the key is it's not clear whether there'd be 9 votes for en banc.
How fast would they have to decide if they're going to take it en banc? Is there a rule on that?
It would move pretty quickly, Katie. There's no there are rules about how fast you have to file, but actually there's no rules that govern how fast the Fifth Circuit would have to vote. And man. I think there'd be pressure for them to move quickly, but only pressure. The other alternative, as you say, is to go right to the Supreme Court. And the upside of the Supreme Court, and here I am about to defend the Supreme Court. Is that I do not
hold the presses. Here we go.
I do not think there are 5 votes for the Fifth Circuit's position on the Supreme Court. The downside is there's no way to wipe away the Fifth Circuit panel's opinion until you've gotten all the way to the end of the Supreme Court case, until the Supreme Court has ruled and has said we're vacating that opinion. And so this is the trick, which is that I actually think the odds of winning on this question are higher in the Supreme Court, but it's a longer path to vacating the panel decision.
You couldn't could you ask for a stay? Could you ask for an administrative stay or something?
Here's the problem. I'm sorry to be sort of the nerdiest nerd in the history of nerds for a second.
That's what we do here. Yeah.
A stay suspends the immediate effects of the Fifth Circuit's decision, and so it would benefit the 2 guys. A stay does not suspend the precedential force of the Fifth Circuit opinion.
So it would still have impact on the remaining people from those other states that we talked about, Mississippi, Louisiana, and Texas.
Right. And so that's why I think probably the best option is to seek en banc rehearing from the Fifth Circuit, but be ready to file in the Supreme Court like the second, that gets denied, if it gets denied.
I promised our viewers that we would talk about Judge Jones, and I'm putting you a little Johnny on the spot, but I did find it to be remarkable and yet consistent with how she ruled and how she wrote. I haven't counted it yet, but I was saying a little bit in jest and yet not really. She likes the word illegal and illegally a lot. And I think that's the way it's being used. I understand she could maybe find cover and plausible deniability by saying I'm using the word illegal and illegally in the context of law, but really I find it to just be derogatory the way that she's speaking to and referring to people.
It's such transparent it's such transparent baloney, because she knows that most of the people who hear that think that means it's a crime.
Exactly.
Right? And I'm just gonna say this one more time, okay? it is a crime to enter the United States without inspection. That is a crime. It is a seldom prosecuted crime. It's a crime. But by some estimates, Katie, as many as 45%, and that, that number might be a smidge high, but as many as 45% of undocumented immigrants did not enter without inspection. Right? They're undocumented because maybe they overstayed a visa, or because they're seeking asylum, or because they had temporary protected status and then lost it. I mean, right? The notion that like every single person who's subject to arrest is necessarily illegal is not just demeaning, it is factually incorrect, right? You can be subject to immigration arrest, and many people are, having never committed a criminal act in your life.
The nuance of which is lost not only on Republicans, but most people, I think. You wrote in another one of your One First newsletters about a visit you did with the Federalist Society at an event last fall in November of 2024. And I just really quickly wanted to ask you, Steve, about it. You wrote, "We didn't trade tyrannies of the majority for a tyranny of unelected judges." And you sat on a panel with Judge Edith Jones, who wrote this opinion in the Fifth Circuit, this horrible opinion. And during that panel, she actually attacked you on a personal basis, whipping out a manila folder of blog posts, tweets, amicus briefs, and other writings that you had done. And it was about this idea of the independence of judges, right? And the fact that judges should be independent, but just because I criticize your ruling or your rationale doesn't mean I'm coming after you personally. I'm attacking your rulings and your rationale. But she hyper conflated it.
Yep.
And then she said that you were directly responsible for death threats that Judge Kaczmarek, who is Matt Kaczmarek in Texas, who the government has admittedly directed and cherry-picked shit to be in front of because of the way that he rules in favor of the government. She blamed you for death threats that he and his family have received. I want the record to reflect, not only is that a lie from Judge Jones, you have never done that, but it was clearly inflammatory. And I just feel like this just shows the animus that Judge Jones has towards things that are objective. And I do think it shows that she's militating towards being inflammatory when she writes the stuff that she does and when she makes accusations like she did against you.
So, I mean, there's a lot here, and I don't want to bore folks with the details. I mean, I have a long post.
I invite them to read your newsletter because it was very clear what happens. You know,
I'll just say this. I think what I think ties these two episodes together is there is a view that I think you find a lot on, especially in my experience when I'm criticized from the right, that conflates substantive criticisms with personal attacks.
Yeah,
and that Katie remarkably then engages in personal attacks without respecting of their own. I mean, there was a remarkable moment during the Federal Society panel where Judge Jones said, this is not a personal attack, and then went on to personally attack me, right?
And then,
so it's part of that, I think, is obliviousness, but part of it is also that is, I think, misunderstanding the difference between being a federal circuit judge and being a law professor. Your job as a circuit judge in public, in your opinions, in your appearances at things like the Federal Society National Lawyers Convention, is to avoid leaving anyone with the appearance that you might be biased, that you might be partial, that you might have an agenda. None of those things, are requirements of my job. I try very hard to be objective. I try to bring receipts for every single claim I make. I try to distinguish between personal attacks, which I am very loath to make, and substantive criticisms. But there's this notion that Judge Jones, I think, has reflected, Katie, for a very long time, and that I unfortunately, I think more and more of her colleagues on the bench are also reflecting, that they don't have to be above it, right? That they can roll up their sleeves and get into the middle of it. And that is not their job. And I think, part of the problem is that what I was so concerned about, the thing that set her off, right, was my attacks on Texas's efforts to steer all of these challenges to Biden administration policies to the same 3 hand-picked judges in Texas, which, as you say, Texas admitted they were doing. And that's an objective determination.
You can look at the cases and where they're filed.
And if you can't tell the difference between criticizing a feature of our legal system and saying something like Judge X is a hack, then I think you might have lost the objectivity that we should be asking for in all of our federal judges. And, that was what struck me about my run-in with Judge Jones in November of 2024. But I wish, Katie, that were an isolated incident. I think we're seeing so much of that from so many of, especially these, Trump appointed and in some cases older Republican appointed judges. And it's a shame for two reasons. One, it's a shame because I think it brings discredit on the federal judiciary. Two, Katie, there are so many Republican appointed judges across the country who are doing yeoman work in these cases,
They're doing the right thing.
standing up for the rule of law, who are, showing us the best of what a judge can do. And when you have behavior like this on and off the bench, it really just, undermines so many of the much more noble efforts of people, Katie, who I disagree with all the time, but who I respect and admire the hell out of.
And this is the reason why I always want to have these, go back to school moments with you, because I think people need to understand, you and I, more you than anybody, we're looking at these decisions with a keen eye towards precedent and law. And we're looking at it through the lens of, again, you more than I, with a scholarly lens. But we're also acknowledging that there is the human factors that exist behind this, right? And I think it's ignorance to suggest that all judges leave their biases and their prejudices at the door when they don their black robes and they make these decisions. And to call these judges out for either intellectually dishonest opinions or rulings is not a personal attack. It's not an ad hominem attack to be able to say that this is intellectually inconsistent with either precedent or with even that judge's own prior rulings on similarly situated cases, right?
Well, and I think what separates out the ad hominem attack from the legitimate criticism is not just the verbiage, it's the substantiation. Right. It's
the justification by the judges for how
and by the critic. Right. I mean, so it's one thing to say, oh, Judge X is a hack. It's another thing to say, I have 15 cases in front of me and I can show you how Judge X rules for this party and against that party, even when everything otherwise looks the same. Those are not the same critique. Right. One is this lazy, 2025 social media, knee-jerk critique. One is actual criticism. And, forgive me, but if there are judges who can't take legitimate, substantive criticism, and who have such thin skin that they're going to use their platform to go after the critics, I think that says a lot more about the judges than it does about the critics. And I think, if anything, it has the unintended effect of reinforcing the criticisms.
Well, amen. And I know you always bring the receipts, which you always do. And I am very proud to say that I am your friend and colleague. Steve Vladeck, thanks for spending this extra amount of time, not only explaining this decision from the Fifth Circuit, but also doing that deeper dive, nuanced analysis that we all need to hear, because we need to have context. I think you're right. There is a through line in the way that these are all connected. And they really are to further, I think, an incredibly draconian goal here. And it's definitely worthwhile us having these conversations. So Steve Vladeck, thanks for being here, my friend.
Thanks, Katie. Always a pleasure to be with you.
Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.